Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome back to another episode of Legal Ease, the show that converts legal jargon into legal ease. And tonight we cover the very important topic of medical negligence. I'm going to be joined tonight by Dr. Henry Lerm. Henry is a doctor in law, an admitted attorney in private practice since 1985. He is a respected member of the legal fraternity in the Eastern Cape, where he has served on various committees involving the legal profession, especially the functioning of the courts, access to justice, etc. Henry is the former president of the Attorneys Association of the South Eastern Cape in Port Elizabeth, and he has a wide range of experience both on practice as well as academically. He holds the following degrees: B.Proc, LLB, LLM, and an LLD from the University of Pretoria. The subject matter of his thesis for the Masters read Necrophilia, an investigation into the origin and nature of crime in South African law and practice. His thesis for his doctorate is titled A Critical Analysis of Exclusionary Clauses in Medical Contracts. His membership of legal organizations includes functioning as a lecturer at the Practical Legal Training School, Nelson Mandela Metropolitan University, in a variety of subjects including procedural law, constitutional law, and high court practice since 1998 until 2018. He has also lectured at the local universities in Port Elizabeth. In 2009, he was engaged by LEAD of the Law Society of South Africa to present lectures to practicing attorneys countrywide in subjects including contract law, legal writing for litigation, medical law, advanced medical law, and legal interpretation. In 2015, he became the first attorney appointed by the Law Society of South Africa to reach out to the medical profession and to teach medical law and ethics to the medical profession. He's a member of the South African Medical Legal Society, a director and the National Deputy Chairperson Legal of the organization. Henry has published articles in law journals including the following topics: the right to silence under siege, two heads are better than one, assessors in the High Court civil cases, exclusionary clauses revisited in the South African context, fracking, an energy dream come true or an environmental nightmare, medical malpractice litigation. Do we need a paradigm shift in our approach to handling medical negligence dispute? Who is responsible for mishaps in the operating theatre at a private hospital? He has delivered papers at conferences including cross-examination, How Powerful Thy Sword, Corruption, the Origin and Nature and Historical Development of the Crime in Perspective, the Impact of the Consumer Protection Act on the Medical Care Services, Minimizing the Risk of Malpractice in Litigation, Medical Malpractice Litigation. The questions he asked was, do we need a paradigm shift in our approach to handling medical negligence disputes? He has appeared in both the high courts and lower courts, and at present he heads the Uitenhage Justice Centre of Legal Aid, South Africa. He has a passion for both medical law and constitutional law and has been involved in a number of constitutional impact matters concerning housing and sanitation. Henry is also a research fellow at the Nelson Mandela University, Port Elizabeth, since Feb 2018. Good evening, Henry Lerm, and welcome to Legal Ease.
Good evening, Ashraf and the viewers.
And thank you very much for taking the trouble to join us. Just for the viewers' information, we are joined via Skype or by Skype with Dr. Lerm, who is at home. Doctor, the present status of healthcare in South Africa, what are we to make of it?
Ashraf, I believe that the unprecedented crisis that we are facing in the healthcare in South Africa, both in the public as well as the private sectors,
And what is the nature? You know, in the press you read of massive claims against the state or the hospital or the Department of Health. I mean, I think even the minister has been complaining about the massive influx of litigation against the department. What are we to make about this crisis, and how can we avert this?
I think, Ashraf, firstly, one must look at what are possible reasons for the crisis. Let's start off with the public sector. I believe equipment that are obsolete that are still being used in the public hospitals, that could be one of the factors. I believe that they're short-staffed in some of the public hospitals. I believe with the influx of a lot of foreigners in our country, where the ratio of doctors treating patients have increased to such an extent that to a certain extent the quality of medical service could be compromised. Other contributing factors, of course, is the fact that in the last, I would say, 5 years or so, the increase in litigation could also be contributed to perhaps the patient philosophy changing. At one stage, you probably know, doctors were viewed as gods by our public mentors.
Yeah.
That has changed. I think that perhaps the introduction of the Constitution in 1996, the Consumer Protection Act, people are more aware of their rights today. They no longer stay to take on the medical profession. And then, of course, the extent to which the churches are starting in South Africa. Another contributing factor is the introduction of the Contingency Fees Act, where attorneys take on these type of cases free of charge, and then they will collect their fees on a win basis. Only if they're successful in the litigation that they recover their fee to an extent of 25%. That, in a nutshell, are the factors that I believe that has driven the extent of the claims that are being instituted at the moment against the public hospitals and as well against the private hospitals and doctors.
So, but how can we avert this crisis? I mean, clearly there is a serious problem. As you've just alluded to, the patients themselves are more circumspect, they're more knowledgeable, and they have a better understanding of their constitutional rights, and they're more demanding, I might say. Although the medical system is skewed and overburdened in many, many ways, how can the crisis be averted?
I believe that the only way we're going to avert the crisis will be through legal reform. And I have recently, as the Deputy Chairperson of SAMRA, sat with Judge Clarkson, who is the Chairperson of the South African Medical Legal Association, and we drafted recommendations to the Law Reform Commission, who is busy investigating how can we change the whole system in order to ultimately avert a major catastrophe in South Africa. As you know, doctors are, especially gynecologists and obstetricians, are leaving the profession in droves, and they're not replaced by juniors who have the desire of specializing in longer. If you want me to highlight certain of the recommendations that we made, I would like to do so.
Yeah, please go ahead, yes.
Firstly, I believe we should start at the medical schools. I believe that the quality of training to a certain extent, I believe, and I've spoken to many people in the medical profession, has to a certain extent been compromised. We do not have enough of the quality practitioners who enter the profession. Also, there seems to be a problem with ethics. I believe that it is a noble profession, and when one enters the profession, it is a calling, and one is driven or should be governed by morality and a high degree of ethics. And I believe that should perhaps be taught at the medical schools before they enter the profession. Other areas that I believe that we should perhaps look at is a risk management system, both at public healthcare institutions as well as private healthcare institutions, that you manage your risk, which I believe is absent at the moment. Another area that I believe that we could look at introducing is peer review. When someone makes a mistake, and I believe that we're all intelligent, we can fail, human frailties that mistake. And if you make a mistake, then that there should be a peer review where your conduct is being judged by your peers, and it might not necessarily lead to punitive sanctions being introduced against you as a doctor, but you may lack competency in a certain field. You may have to undergo certain training to sharpen your skills in a certain direction, and in that way you may not repeat that mistake again. That is an area that I believe that we should seriously look at in South Africa. Then maybe the area of contingency fee arrangement. I believe that perhaps lawyers at the moment are entitled to charge no more than 25%. Some attorneys have overreached and may feel the wrath of the law in the future, but I think that perhaps the percentage of contingency fees should perhaps be lowered to perhaps 12.5% or so.
So you remove the incentive for the attorney to chase us. Doctor, I'd ask you to just pause there, please. It's time for a break, and the viewers could please join us after the break. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome back to Legal Ease, the show that converts legal jargon into legal ease. And tonight I'm joined by Dr. Henry Lerm, who's actually an attorney with a doctorate in laws. And we're discussing a very, very important subject, which is medical negligence. And thus far we've heard that the present status of healthcare in South Africa is extremely precarious. Doctors are being sued, hospitals are being sued, and Dr. Lerm was helping us understand how the crisis could be averted. He stopped at the point where he indicated that there were certain recommendations made by him, and in his view, attorneys that act on contingency fees, that fee should be reduced from 25% to about 12%, which disincentivizes the attorney from taking on a case just for the sake of running the matter. Dr. Lerm, please go ahead. What other mechanisms have you identified to avert the crisis?
Thank you, Ashraf. Another area that I believe that we could look at is to reduce litigation and rather embrace the process of mediation. Mediation is a speedier way, less costly way, and also a way in which you could do it on a without prejudice basis. If the parties cannot come to an agreement, then that matter could be litigated in the end. And perhaps, that's one of the recommendations that we at SAMLA had made to the Law Reform Commission, that litigation be made mandatory. So in other words, before the parties resort to litigation, they should give it a chance to have these matters mediated. Another area that I believe that we should look at, and that's also been a recommendation of ours, with especially cerebral palsy children, those claims, there are huge amounts being paid out. You're looking at 23 million rand being paid out to a child. I have had one or two of those matters in my career where we have gone to court, and in both instances, the children never lived beyond the age of 12. So presently with our pension system, you pay out, we call it the once and for all rule. So compensation is given based on your claims, which we institute now. And there are life expectancies and so on, but as you know, that cannot be determined with great certainty. So with the result, these huge amounts are being paid out to the parents. I see the courts now insist that trust must be created, but nevertheless, the child dies, and who sits with the money in the end? The parents sit with that money. And litigation was not in respect of the parent, but in respect of the child. So that's another area that I believe that perhaps we should look at periodic payment. As the child is in need of medical equipment, medical treatment, et cetera, that only then would certainly money be paid over to assist the child.
So along the lines that the road accident fund has basically taken, would that be what you're thinking
yes,
about?
Yes, that's correct. And there could be perhaps capping on claims as well. That's another area that we could look at. And in the end, there would be more money available, because my concern at the moment is this. Budgets are being depleted, especially at public hospitals, to such an extent that they exceed their budget and they dip into line items in terms of the budget, which was designated to replace obsolete equipment. With the result, the hospitals still sit with obsolete equipment, leading to further medical malpractice practices at the hospital. So it is a situation that, as I said earlier, unless we can stem this tide, we're facing major catastrophe in the state.
That is very, very frightening indeed. Doctor, if I have a claim, who do I address the claim to?
It depends on where the patient is. If you found yourself in a public hospital, obviously you would sue the NBC for help in the process where the claim arose. You could sue the hospital. You would not sue the nurses or doctors who are employed by the MEC, because through their conduct, the MEC incurs what we call in legalese vicarious liability. You're an agent of the MEC for that reason then. The MEC has the first, and the MEC will then ultimately pay the damages. With a private hospital, it is totally different. If your claim arises from conduct of, say, the nurses in the private hospital, then you would claim against the hospital itself. If there are doctors operating in a theatre who are private agents, they don't work for the hospital, you will not sue the specialists or so, provided, of course, they weren't negligent themselves, because if they were also negligent, then you would have a claim against both the hospital and against the doctors or specialists.
Okay, and a reminder to our viewers that you can call in and join the conversation if you are a victim of medical negligence or if you want to find out more about medical negligence. Dr. Lerm, is there a time period in which to claim?
Yes. In South Africa, in terms of the Prescription Act, you have 3 years from the time you reasonably establish that you have a claim. You have 3 years in which to issue summons against the wrongdoer, the person which you think wronged you, and for that reason you institute this claim. Insofar as minors are concerned, they have an additional year, so they have to issue summons within the year in which they turned 19.
Oh, I see. So, but if you are proceeding against a minister, for example, you first have to comply with certain prescribed steps. For example,
Yes.
you have to, please expand on that.
Yes, thank you, Ashraf. In terms of the State Liability Act, where a claim is founded against the public hospital, for example, you have 6 months in which to give notice to the minister, the MEC. You have 6 months in which to give notice. If you don't give notice in which you set out your claim in the form of that notice, you have to ask for condemnation. If they don't grant you condemnation, then it's a matter of you have to bring a substantial application in the High Court also, in which you ask the court to condone your failure to bring or to set up that notice and to give notice to the MEC. That's another area which we, as SAMLA, made recommendations to the Law Reform Commission that we believe that should fall away. And like all undertakings, the 3 years, there's no reason why you should give notice to the MEC.
Okay. Unfortunately, I'm sorry to break, but we have to go for a short ad break. Please stay tuned and join us after the break. Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome back to Legal Ease, the show that converts legal jargon into legal ease. And tonight we are dealing with a very, very important topic, that of medical negligence. You might be a doctor who is being sued, or you might be a patient who was badly treated, and you might believe that you have a claim. So, as always, you are welcome to join us with your comments by calling in to the studios. And I'm hosting Dr. Henry Lerm, who is actually an attorney who has a doctorate in laws. And his passion is medical law and constitutional law. We have been discussing who you could claim from and how do you sue, and what technicalities you must comply with before you can actually bring a summons. We were dealing with a time period in which to bring the claim, which is prescription. But Doc, how do we approach the litigation process itself?
As an attorney, and I regard myself as a prudent attorney, having done these cases and also with the experience that I've gained about medicine throughout the years, medicine is not an exact science. One can never guarantee results. When babies are born, it is a miracle sometimes that babies come out and are born without any abnormalities or so. And for that reason, I believe that these type of cases should be taken on with caution, fully investigated. Experts should be engaged before the time, before one enters the phase of litigation. Another area of concern of mine is the attorney may claim to decline that I will take 25% of the capital amount if we win. And I'm not saying all attorneys, but some attorneys fail or neglect to tell the client, yes, if we lose, I will waive my fees, but you're still in to pay the cost of the other side. And I want to highlight that any person who approaches an attorney and instructs him or her to engage in litigation in malpractice should ask the attorney about the cost implications, not only in terms of the Contingency Fee Act, but also about paying the other side if they lose.
So that's a very, very important point. But just as an aside, a contract between the attorney and the client dealing with contingency fees itself has to be registered with the Law Society so that it becomes a public document and we avoid the so-called common law fee arrangements that we've seen that have been smashed by the courts. There was a very prominent father and son attorney dealing with RAF matters that has been in the press, and basically the courts have held that that common law fee arrangement where you claim more than 25% was not going to fly. But I think you make an extremely important point that when assessing litigation, in the event that you lose, you might be saddled with those wasted costs yourself of the other side. A very, very important point indeed. Now, we've covered mediation as a means to resolve the dispute, and I know that in the magistrates court there was a pilot project to try and bring in mediation as a means to resolve disputes in civil matters. There's no such rule in the High Court, is there?
No, and this is why, Ashraf, we at SAPLA made recommendations that the Law Reform Commission should run with that process, and perhaps the High Court rule should also be changed then as they change the Magistrate Court rules to make mediation mandatory, as I stated earlier.
And the nice thing about the Magistrates Court, it's court-assisted mediation rules, but it can be either at the instance of plaintiff or defendant, or even the presiding officer himself, who can decide that, look, I think this matter needs to receive more mediation than litigation. But to come back to our topic at hand, in order to succeed with a claim, what must you prove?
Well, you have to prove that there was negligence. Now, how do you prove that there was negligence? The conduct of a nurse or a doctor or a specialist is measured against how would a reasonable nurse, a reasonable doctor, or a reasonable specialist have acted under those circumstances. I can also add that the degree of care and skill of a specialist is higher than a general practitioner. Unless a general practitioner finds himself or herself doing work of a specialist, for example, a plastic surgeon. If a GP does plastic surgery, then the standard of care and skill imputed to him is the same as the plastic surgeon. So you have to prove the wrongfulness. Part could be in the form of negligence or intention. You have to then through causality that that conduct caused the damages that were caused in the end to the patient.
Now, just by way of example, I know we haven't discussed this, but what are some of the strange cases that you've come across regarding, let's say, intentional damage?
Intentional damage could arise as follows. You fill with the patient. You don't have the tolerance level in the long term because the patient doesn't want to listen to you, and you then deliberately ignore the further treatment of the patient. But you don't tell the patient that, please go and see another doctor, I'm not going to treat you any longer. You leave that patient in a limbo, and the condition of that patient may worsen. Then the law would regard that as intentional. Negligence is totally different. It is a matter of foreseeability, and you may not intentionally have caused the damages to the patient, but you were negligent in that you didn't act as a reasonable average practitioner in that class would have acted.
So what about the situation where, for example, you're given the wrong medication, and instead of your condition improving, you actually, it could result in death or in disability? What test would we allow? What test would we use there?
Well, once again, you go back to whoever prescribed the medication. Would they have subjected the patient to certain allergy tests, etc., to see if the patient, if it's compatible with the patient in taking that medication? If you fail to do that, you once again judge in terms of how your peers have acted under those circumstances. Would they have tested the patient before prescribing the medication? And if the answer is yes, they would have, but you failed to do that, then your conduct would be regarded as negligent.
So, and what is informed consent? And can the doctor basically hide behind that shield and say, but I had informed consent? So, first question is, what is informed consent?
Yes, thank you for the question. I think it's a very important question, because more and more patients question the conduct of the doctor or specialist after the fact. Now, let's look at before a doctor can, let's say, examine or treat a patient. The doctor or specialist has to get the consent of the patient. If they fail to do that, their conduct will be regarded as an assault, and they could be sued for ignoring that. Now, informed consent, with the emphasis on informed, means that maybe there's a procedure or so which is a high risk, and you as a doctor or specialist have a duty to explain to the patient about the implications, about the risks that may accompany such procedure. If you don't adequately explain to the patient the consequences or implications that may belie that, you may then have failed in your duty to adequately receive or explain to the patient before you receive their consent. And that is what is known as informed consent. If something then goes wrong, where you have apprised the patient of the risk and the complications of so. And as I stated earlier on, medicine is not an exact science. And for that reason, anything can go wrong during an operation or during treatment of a patient. And if the doctor adequately explains to the patient the risk, then he won't, the patient won't be successful in suing the doctor or the specialist.
But, Doctor, in the scenario that we're talking about informed consent, on a practical level, I think it's quite difficult for you to be fully informed. For example, you're on the bed and just before you're being wheeled into the theater, they give you these forms to sign. Now, you haven't even read those forms and you signing these forms. Does that amount to a danger for you?
I believe that if you get a patient to sign just before the patient enters the theatre, with the anxiety levels rise, and we're human beings, we don't like to go to these operating theatres. If you explain quickly to the patient, the explanation may not be regarded as an adequate explanation or an adequate warning about risks that you give to the patient. So the doctor will not successfully rely on proper informed consent.
Okay, Doc, that's a convenient place to stop. We're going for a quick ad break, and to our viewers, join us after the break. Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome back to the last section of Legal Ease, the show that converts legal jargon into legal ease. Tonight we were discussing the very, very important topic of medical negligence, which is a topic of interest both to the doctor as well as to the patient. I was joined by Dr. Henry Lerm, who's actually an attorney, a very, very well-informed attorney, and one with immense experience in this field. Just before the break, we were talking about informed consent and what it really means. But I think now we'd like to move on to what damages can be claimed and how are these damages proved. Dr. Lerm?
Thank you, Ashraf. We call them in law, there are different heads of damages, which basically mean different types of claims for damages. In the one claim that you formulate when you're litigating, firstly, you can claim for hospital expenses, past and future. In other words, whatever treatment you had to undergo in the hospital, claim those damages, and whatever you may have to undergo in future, you can claim that. Medical expenses, past and future.
So sorry to interject, Doc.
Yes.
So when you talk about hospital expenses, it's the actual charge for the hospital, and then you're talking about...
That's the actual, yes, you produce the vouchers, you show them the accounts which you received, and they will compensate you for that. With future medical expenses, it's a little bit different there. You will rely on the expertise of an expert, medical expert, who will give a report in which they quantify what future hospital and medical expenses you will incur.
Yes. I'm thinking of cases where there's severe damage like burns, etc. I think that I read somewhere that a patient was burnt in hospital because they got into a bath of hot water. I mean, there's clear negligence there by the nursing staff. I mean, it wasn't medically connected, but it was injuries sustained while in hospital due to them not checking the temperature of the water.
Yes.
So that will include plastic surgery and whatever else you need in the future?
That is so, yes, indeed so. And then part of that would also be for pain and suffering, past suffering, pain and suffering which you have to endure, as well as any future operations or so, where it will be accompanied by some more pain and suffering and discomfort, loss of amenities of life, you cannot play sports, etc., etc. The additional type of damage that one can claim, and that is called your general damage.
Now,
then you can also, sorry?
So, a lot of patients ask, but, I suffered for so long mentally, and can you claim for mental anguish, if I can put it that way?
That's a very good question. For many years, you couldn't. You could now, but you will have to show that you underwent some form of psychiatric treatment or so. It's like emotional shock, for example. You could claim now for emotional shock, but there's a difference between a heart sore. You lose a family member and you are heart sore about that. But in order to be successful with emotional shock, you basically have to witness what happened to the patient, or it would be in the effect of perhaps someone who died also. But you have to show that you underwent some form of psychotherapy or stuff before you will be successful to claim that particular bit of damage.
So you can't just put in a claim for any amount without really being able to prove that, independent of what you're saying.
Yes. And also, what I want to emphasize here, Ashraf, is the following. In these type of matters, you cannot possibly go to court and claim damages unless you engage in the services of an expert witness.
So I've heard you say that quite often tonight, and I think that's the key to this, to the successful claim, which is one, to employ an attorney with competence, and two, to have the proper experts on your side that lead evidence on your behalf.
That's correct, yes. And I'm glad you used the term proper, because at the moment that's another worrying aspect in South Africa, that there are too many of experts who give themselves out to be an expert, but are they really experts? We witnessed that in Oscar Pistorius' trial, which has got nothing to do with medical negligence, but there was a prime example of certain of the experts who came to court to give evidence, who made themselves out to be experts, but unfortunately they were biased, some of them, and it's a matter of, you cannot be held in esteem as an expert witness unless you are unbiased, you are objective, and you come to court as a witness of the court and not as a witness for the plaintiff or the witness for the defendant. And other recommendations which we have made to the Law Reform Commission is that there must be some form of accreditation in South Africa when it comes to expert witnesses, where if you accredit it, you are known to be an expert, and only those should be used in these type of cases.
Another very important topic, which we probably won't be able to finish tonight, is there's a belief that certain patients or members of the legal profession are abusing the rights. And how would one know when there isn't an issue that's triable? I mean, at which point does one know this?
Ashraf, I believe that perhaps the time is right that one should have some form of a merit certificate that needs to be completed it's a practice in Australia, for example, where you investigate fully a potential claim, and only then, if you have investigated that fully and you have expert witnesses to back your claim, that you could perhaps complete a certificate of merit, which is handed up to the court. And, with litigation, never a degree of certainty whether you're going to win. But there are too many of these cases that are being formulated at the moment, medical malpractice cases, where these matters have not been sufficiently investigated. And I want to make the following statement. These type of cases are unlike road accident fund cases. We have doctors whose reputations are at stake here, and I'm not trying to color for these doctors. I believe that where you have a meritorious claim, patients should be compensated. But if there is inadequacy and you never really had a claim, what we call a baseless claim, then the court should deal with lawyers there. And at the moment, what's happening in South Africa is there's more and more punitive damages being awarded against attorneys who bring what we call frivolous or baseless claims to the court.
But having said that, Doctor, having said that, it still appears to me a ginormous amount of money being paid out. In Gauteng in 2017, I think they paid something like 1 billion rand in lawsuits. And the Eastern Cape, one of the poorest parts of the country, they're facing payouts of up to 14 billion. Unfortunately, we've run out of time, a very, very important and interesting topic. It just leaves me a few seconds now to thank the viewers and to thank my guest, Dr. Henry Lerm, which I hope to invite back at another stage to take this discussion forward. I thank you for your attention tonight and keep well. Assalamu alaikum wa rahmatullahi wa barakatuh.